he does extremely well is ask questions. And so he has been designated by Senator Thurmond, who's the ranking member on this committee, to be the chief questioner of Anita Hill and her witnesses for the Republicans. And on the Democratic side, again, we have two people who are experienced with the criminal justice system, Patrick Leahy, a former prosecutor, and Howell Heflin, who's the former Chief Justice of the Supreme Court of Alabama. And Chairman Biden is sitting in his chair now, talking briefly to Senator Kennedy. We did see this morning, I thought for a few minutes this hearing was going to fly apart because after Judge Thomas's opening statement, Senator Biden announced that he was not going to question the nominee about Anita Hill's affidavit since she wished it to remain confidential publicly until she could testify with some completeness. Well, that provoked Senator Hatch to go quite nuts, saying, this has been in the press. National Public Radio has it. He didn't mention us by name. And sections of it had been on the air, and this is outrageous that we can't question based on this affidavit. And then the committee quickly went into closed session to try to figure out what to do. They were closeted in closed session for about a half an hour. When they came out, they adopted the suggestion that had been made publicly by Senator Kennedy just before they recessed, which was, let's hear from the judge first, just with an opening statement, then let's hear Professor Hill, question her, and then move on to questioning Judge Thomas. Anita Hill has just re-entered the hearing room, is seated, and presumably we will be back to questioning momentarily. I realize I keep saying that, but we can't hurry the process along. This committee may well be here till 7 or 8 o'clock tonight or later. It's obvious we're going to go over until tomorrow. They're talking even about Sunday. They are quite determined to try to finish with Judge Thomas by the end of today. Chairman Biden is banging the gavel once again, so let's go to the chairman, Joseph Biden.
This next round of questioning. Through what I know to be inadvertent, the statement that was given to Professor Hill was also for the first time, the affidavit was also for the first time made available to the committee at large without the knowledge of the senator from Pennsylvania, realizing that we did not have it either. There has been an agreement from the outset of this proceeding because, as I said, this is not a trial. This is a hearing to seek the facts, that everyone on the committee would be have made available to them any and all documents that are produced for whatever reason before there is any introduction of such documents in the record or before there is any questioning on any document. That applies to Professor Hill. That applies to Judge Thomas. That applies to all our witnesses. Now, again, I think this was, in this case, inadvertent, the way it came about, and in order, the Senate has indicated to us they wanted this very important and difficult matter resolved, and they gave us essentially 48 hours to get ready for this. So there's going to be a lot that drops between the cup and the lip here, but one of the things that will not will be, from this moment on, any document that all members of the committee have not had in sufficient time to examine, read, think about before it even is presented, if there are any to be presented, or questioned on by of a witness. No. With that, I now, and while we're doing a bit of housekeeping here in such an important matter, let me suggest that, again, what is the committee's intention in terms of timing. The committee's intention is to go back to Senator Specter, and he indicates he may have more questions than his next half hour. And Senator Leahy indicated that he has some more questions. It is my sincere hope, Professor Hill, that we do not keep you much longer. we will do at the conclusion of Senator Senator Leahy's questioning, we will then do what I indicated at the outset. Each member who has not asked questions, all of whom have a keen interest in this matter, will have up to 5 minutes to ask a question or questions within that 5-minute period. We will then, God willing, excuse Ms. Thomas, Professor Hill, and call Judge Thomas, I beg your pardon, back this evening, and hopefully complete Judge Thomas's testimony tonight before we go tomorrow to other witnesses. I thank you for your patience, Professor Hill. And again, as we have with all witnesses, if at any point during this process, as I have indicated to Judge Thomas and to every witness before us, you have any requirement or desire to ask for a break for whatever reason, you need not have any reason. You just indicate to the chair, and there will be a break. We will recess. Now, with that, let me yield to my friend from Pennsylvania, Senator Spector.
Thank you, Mr. Chairman. Mr. Chairman, as you had noted, I had not known you had not seen the Doggett statement, but in any event, the interruption gave both Professor Hill and other members of the committee a chance to see that statement. Professor Hill, copies of that statement. Copies were made available to you over the break, and I ask you now if you would have any objection to answering questions about that statement.
No.
All right, it may be that Mr. Doggett will appear as a witness. If he does, it would be appropriate to give you a chance to comment, and rather than have you come back after the fact, you can comment now. And I had, candidly, some question in my mind about asking you about this statement at all, but our lines of inquiry at this kind of a proceeding are very different from any other kind of a proceeding, but you've now had a chance to read it. You are willing to comment about it.
Yes, I will.
I bring up the statement of Mr. Doggett because of the statement which was made by Dean Coffey that you've already commented about, where Dean Coffey of the Oral Roberts Law School made a statement about fantasy, which I don't intend to repeat again, but that comes up in the Doggett statement. The Doggett statement is a long statement, and I'm going to summarize it by reading a portion of page 2, and you, of course, Professor Hill, are free to bring up any other part of it you want if you'd like to go into any of the rest of it.
Yes, you may, Senator.
Understanding that to follow this procedure by accepting this affidavit and inquiring of the witness in connection with it, that you open up a literal Pandora's box, because we can get all sorts of foreign statements. I see a number of them that were handed to me a little bit ago, and it seems that there's no end. It's my understanding further that there was some limit as to the number of witnesses that would be called by Judge Thomas, who was interested in his confirmation, number by Ms. Hill, and my question is, what are the rules?
Senator makes a valid point that we had agreed to a witness list submitted by Judge Thomas or by the minority, and a witness list that was submitted on behalf of Professor Hill, and that we were of the understanding that that was the totality of the witness list. There was an agreement that there would be no witnesses called other than those witnesses absent either side, shouldn't say either side, the entire committee being informed of and deciding on whether or not to issue a subpoena to any witness that had not heretofore been mentioned. Now, obviously, Mr. Doggett's affidavit, it would seem to me, at a minimum, will require Mr. Doggett to come forward and be under oath, at a minimum. So, by implication, we have changed the ground rules of who would be witnesses and under what circumstances. And I would suggest that it may not be inappropriate to question Professor Hill on Mr. Doggett's statement, but not absent the opportunity of the majority to be able to question Mr. Doggett. Every witness that has been put on the witness list, I've insisted that both the majority counsel and the minority counsel both simultaneously interview that witness and listen and have an opportunity to question that potential witness, I should say. And in the case of Mr. Doggett, that has not occurred. Now, unless my colleague from South Carolina would object, it seems to me that it is not appropriate at this moment to question Professor Hill, notwithstanding her willingness to be questioned. I am told that Mr. Doggett is scheduled to be interviewed by majority and minority staff at 5 o'clock today. 5 o'clock. I would respectfully suggest to my friend from Pennsylvania it would be more appropriate to question Professor Hill on Mr. Doggett's assertion after we have had an opportunity, all parties on the committee have had an opportunity to speak with Mr. Doggett, so that other senators will have an opportunity to intelligently question Professor Hill on Mr. Doggett's statement, and after having spoken to, staff having spoken to Mr. Doggett. So unless my colleague from South Carolina would object, I would suggest we postpone any questioning on Mr. Doggett, although it may be totally appropriate to do so, until the full committee has had a chance, as per our agreement, to interview Mr. Doggett, so we are all prepared and are able to ask intelligent follow-on questions.
Mr. Chairman, I do not object, just provided that we have the opportunity to question Professor Hill after Mr. Doggett has testified.
Professor Hill, this may mean that you would have to come back. And I would I'll leave the choice to you, but I would respectfully suggest it is better to us have an opportunity, all of us, to question Mr. Doggett before you are questioned about whatever Mr. Doggett had to say. Would you like time to confer with your counsel?
Yes, just a moment, please. Come back, if necessary, to respond to Mr. Doggett's testimony.
Well, it may be possible. I'm not promising this. It may be possible we can do this by interrogatories or foreign interrogatories or by affidavit, but I do not make that commitment. The only commitment I'm making now is, it seems to me fair, is for the committee to be fully informed prior to your being questioned on this matter. Yes. Yes.
I haven't perhaps been privy to some of these agreements that have been made, but it seems to me there's nothing wrong. I'm sorry. It seems to me there's nothing wrong with, while the witness is here, asking her about these questions about, this particular statement. She was willing to answer it, and I think you saved time by doing it. And frankly, I don't see any problem with that. And, I think the senator could have.
She's willing to go
He can
ahead.
ask
We
any.
have no objection.
He can ask any questions he wants. Maybe we won't call about it, but at least he should be able to ask her if this is true, or if this
is what happened, and she can answer. She's had a chance to look at the statement.
One simple reason why I would not like to go forward now. And quite frankly, it is not totally as a consequence of whether or not we're being fair to the witness, which I think would be somewhat unfair to them. It's simply that I don't know enough to know. I want to be able to question contemporaneously the witness on this issue when she's being questioned. And it seems to me that it is, as I said at the outset, this is not a trial. We're just trying to find out the truth. And the best way to find out the truth is for everybody in this committee to have ample opportunity to review whatever is going to be introduced in evidence so that we can all intelligently question on the matter. I yield to my friend from Vermont.
It merely echoes what you said, but I know that we've laid pride in fairness to everybody involved, the administration, Judge Thomas, Professor Hill, and everybody else. We've worked out ground rules that you and Senator Thurman and the rest of the committee have agreed to. This would go out, and we've all had to develop whatever we were going to do within those ground rules. This would go outside them, and as one who has been designated to ask questions, I would find it very difficult to do any kind of a follow-up on this, not having been able to at least delve into a statement of somebody who's not going to be a witness, but a statement to be used almost as though they had been. And for the sake of a few hours delay or whatever it might be, I would rather do it in a way that all of us, those asking questions based on the statement, those who may want to follow up questions based on the statement, at least know what the facts are.
Thank you.
I haven't heard of this, but you can't ask the witness questions. Now, admittedly, we may decide that we don't call this man as a witness, but it's a verified statement, as I understand it, and she may agree or not agree with it, and that's going to be her privilege. But she did read it. She said she was willing to testify, and I don't see any reason why he can't ask questions about it. It's relevant to the proceeding.
Now, Mr. Chairman, I don't think we ought to attempt to require her, but if she's willing to go ahead, then we can save time, I think.
Let me ask Ms. Hill, and then we'll end this right now. Ms. Hill, would you prefer to wait till we have had a chance to, all of us had a chance to interview Mr. Doggett or our staff, or would you prefer to go now?
I can, that's a hard choice if the committee
Well, then the
needs
chair
some.
will make the choice. We will wait.
I can comment on the statement now. I'm not sure what the statement is supposed to mean.
That's the problem.
And it's really baffling me. I'm really confused by it, but it's meaningless to me. So, but it's
Move forward now or not?
Excuse me, sir, just a moment, please. Just a moment.
I think whichever she prefers.
I agree. Whatever the witness prefers, we'll do.
Chairman, I might say that it's because
If it's
the affidavit is so meaningless to me. That's why I wanted to question further. But
if the chairman recommends that we wait, I'm perfectly happy to wait.
I have no recommendation.
Okay. So you are going to
I
make me
am
decide,
prepared.
aren't you?
If it were left to me, I would want to abide by the rules that we had. But
Yes.
if the witness prefers to go, there is no problem. She may go.
Well, I would prefer that we abide by the rules that we have then.
All right. Then we'll wait. Yes.
Yes, we were all in the hall during the recess. The media has this affidavit, and they're not going to wait for anything.
True, they don't.
And so you know that. And I just say that to you as a lawyer, that it will be circulated. It is now going out, and there's no response from you. And I just say that to you as a lawyer, that it will be circulated. It is now going out, and there's no response from you. I would think that obviously this man should come and testify. I would think that he automatically qualifies as a witness. The other witness yesterday, Angela Wright, I was told about yesterday afternoon. They took a deposition from her yesterday, and I saw it last evening. And she said, although the headline was new and dazzling evidence, she said, quote, "I am not stating a claim of sexual harassment against Clarence Thomas. It's not something that intimidated or frightened me. At the most, it was annoying and obnoxious," unquote. So surely, if we're going to have, we are going to have fairness, and we have had fairness. But this is an extraordinary document, and it is not a statement, and nor was your a notarized statement when you began. It is a sworn statement. It is an affidavit. And so I think that I'm ready to do anything you wish, but the feeding frenzy is on.
There is no right answer, I expect, to this, Professor Hill. And then let me finish, if I may. With regard to the person referred to by the senator from Wyoming, immediately upon us being aware that such a person existed, we immediately contacted, within 20 minutes, less time than that, staff, all staff, and any discussions that took place with that person were done jointly. But I only say that to put him at rest. We're going to end this. I see your counsel has indicated that it may be well for you to go forward. And if that's your decision, we will go forward. Let's go forward. From now on, though, as I said, no document will be put in place until every member has had time, and we'll abide by your counsel's recommendation to you. Yes. And, sir, who are you? Sir, I beg your pardon. Yes, sir, who are you?
Counsel to Ms. Hill. I'm trying to explain. She is ready to answer questions to the best of her ability, now or later. And that the issue of whether or not you bend your rules a little bit
I understand
is
that.
not ours.
Yes.
It is yours.
Yes. Sir, and this is the last statement I'll make. It is very easy for me to insist on the committee rules being followed. But you and her other counsel may rightly conclude that Senator Simpson is correct. It will mean that this affidavit will be sitting out there for 2, 4, 6, 8 hours unresponded to. That is not a judgment. This is not a court of law. I am not prepared to make the judgment whether or not Professor Hill, having gotten in this situation, is prejudiced by the fact that she cannot respond. That is why the chair is not going to rule that the committee rules must be adhered to. And they are not the committee rules. They are the ground rules that were laid down, what is obviously an extraordinary, unusual, and unprecedented hearing. So, ultimately, we must look to the witness and her counsel to determine what is in her best interest, not the committee's best interest. From the beginning, the interests at stake are those of Professor Hill and those of Clarence Thomas, not the committee. Now,
Will there be an opportunity to respond to the witness if he is called?
yes, you'll have an opportunity to respond today, this moment if you wish, and to the witness if he is called.
I'm ready to go forward.
Senator Spector.
Thank you, Mr. Chairman, but I think my time is up. Mr. Chairman, I would just like to say initially for the record that I did not make this statement available to the media or anyone.
I understand that, Senator.
And
I
the
know you
ruling,
better.
and the election is to proceed questioning on the statement.
The election of the witnesses to proceed, knowing that we may call Mr. Doggett here to testify under oath, if we so deem necessary.
Thank you, Mr. Chairman. Professor Hill, I had started to question you about this affidavit and had desisted in mid-sentence because I wanted you to have an opportunity to read it. And there's a concern on my part about the document, but I think it has sufficient value. And since you are willing to respond to it, I'm going to discuss it with you briefly. This is an affidavit provided by a man who knew both you and Judge Thomas. And its relevancy, to the extent that it is relevant, arises on page 2, where Mr. Doggett says the following. The last time I saw Professor Anita Hill was at a going-away party that her friends held for her at the Sheraton Carlton Hotel on K Street just before she left for Oral Roberts Law School. During this party, she said that she wanted me to talk in private. When we moved to a corner of the room, she said, quote, "I'm very disappointed in you. You really shouldn't lead on women and then let them down," close quote. When she made that statement, I had absolutely no idea what she was talking about. When I asked her what she meant, she stated that she had assumed that I was interested in her. She said it was wrong for me not to have dinner with her or to try to get to know her better. She said that my actions hurt her feelings and that I shouldn't lead women on like that. Quite frankly, I was stunned by her statement, and I told her that I felt her comments were totally uncalled for and completely unfounded. I reiterated that I had never expressed a romantic interest in her and had done nothing to give her any indication that I might be romantically interested in her in the future. I also stated that the fact that I lived 3 or 4 blocks away from her, but never came over to her house or invited her to my condominium, should have been a clear sign that I had no personal or romantic interest in her. I came away from her going-away party feeling that she was somewhat unstable and that in my case she had fantasized about my being interested in her romantically. On page 3, it was my opinion at the time, and is now my opinion, that Ms. Hill's fantasies about sexual interest in her were an indication of the fact that she was having a problem being rejected by men she was attracted to. Her statements and actions in my presence during the time when she alleges that Clarence Thomas harassed her were totally inconsistent with her current descriptions and are, in my opinion, yet another example of her ability to fabricate the idea that someone was interested in her when, in fact, no such interest existed. And there's an affidavit. My question to you, Professor Hill, is Mr. Doggett accurate when he quotes you as saying, quote, "I am very disappointed in you. You really shouldn't lead on women and then let them down," close quote?
No, he is not.
What, if anything, did he say to you?
As I recall, before we broke, I told you that I had very limited memory of Mr. Doggett. The event that he is talking about was a party where there were 30 or 40 people. I was talking to a lot of people. They were people who I had known while I was here in Washington, and we might have had some conversation, but this was not the content of that conversation. I have very limited memory of him. I do not at any time have any fantasy about a romance with him.
In the earlier part of his affidavit, he says that he met you in 1982 at a gathering of African-American lawyers on Capitol Hill, and that he had a number of contacts with you. Are his statements in that regard accurate, if you recall?
As I said, my memory of him is limited. I do remember at some point seeing him jogging near my home, but beyond that, I have a very limited memory of any interaction that I had with him or how I might have met him, anything like that.
I'm shifting now, Professor Hill, to a key issue regarding your testimony that you moved with Judge Thomas from the Department of Education to EEOC because you needed the job. That is your testimony, correct?
Well, I think that's your summary of my testimony.
Well, is my summary accurate?
Well, I said that I moved to EEOC because I did not have another job. This position that I was not sure whether I would have a position at the Department of Education. I suppose that could be translated into I needed the job.
Okay. I am informed, Professor Hill, that you were a Schedule A attorney and in that capacity could stay at the Department of Education. Is that incorrect?
I believe I was a Schedule A attorney, but as I explained it, I was the assistant to the chair of, assistant to the secretary, assistant secretary of education. That I had not been interviewed by anyone who was to take over that position for that job. I was not even informed that I could stay on as a Schedule A attorney, and as well as I stated before, the agency was subject to being abolished.
But as a Schedule A attorney, you could have stayed in some job.
I suppose, as far as I know, I could have, but I am not sure because at the time the agency was scheduled to be abolished. And I would add, too, that one of the things that I have made the point about before was that the activity had ended at that time. And I enjoyed the work. I wanted to do civil rights work. But I didn't know what work I would be doing if I could have even stayed at the agency or at the Department of Education. I moved on because I assumed that the issue of the behavior of Clarence Thomas had been laid to rest, that it was over, and that I could look forward to a similar position at the EEOC.
Well, I understand that you have given that reason that the behavior had ended so that you have given a basis for not expressing a concern. But your statements in your earlier testimony involved your conclusion that you would have lost your job. And I'm now, excuse me?
That was one of the factors.
That was one of the factors. And I'm now asking you about the correctness of that in light of the fact that you were a Schedule A attorney, and while you would not have been Judge Thomas's assistant or perhaps the assistant of the assistant secretary, as a Class A attorney, you could have, in fact, kept your job had you wanted to stay there.
That really was not my understanding, sir, at the time. I understood that my job was going to be lost. That was my understanding.
Well, did you make an inquiry?
With whom?
Anyone?
I did not make an inquiry. I went on what I was told in my conversation with Mr. Thomas.
Well, Judge Thomas was replaced by Harry Singleton.
Yes.
And Harry Singleton, in fact, according to an affidavit provided, was prepared to retain you as one of your attorney advisors, one of his attorney advisors. Now, I pursue this in some detail, Professor Hill, because on your prior statements, as well as your testimony here, and in extensive newspaper accounts, there has been a major question raised about why you would leave with Judge Thomas, considering your statements about his sexual harassment. And I understand that you have given as part of your thinking the cessation, so perhaps it wouldn't arise. But there's been a major basis for your leaving the Department of Education because you would have lost your job in a 25, as I recollect the press accounts in your statements, you needed a job. But on inquiry, it is determined, number one, that as a Class A attorney, you could have stayed at the Department of Education in an attorney's job. And secondly, that Harry Singleton, who took Judge Thomas's position, was ready to retain you as one of his attorney advisors had you made an inquiry. So that leads to the question, just how concerned were you about losing the job when you made no inquiry about your status to keep a job as a Class A attorney, or any inquiry with the successor, Assistant Attorney General, who was prepared to keep you?
About the method of procedure. What we have now, within the last 15 minutes, we were presented 5 pieces of paper, some of which are notarized, some of which aren't, various people making certain statements. And now we find my friend Senator Specter is in, and before that we had been presented the affidavit of Mr. Doggett. Now we find that this lady is being called upon to respond to these statements, some of which are notarized, some of which aren't. But what we're doing is we're introducing a whole new element of testimony, and this means by inquiring of her. And frankly, Mr. Chairman, I feel it violates the rules under which this committee, you told us this committee was operating, which I think we all agreed to, and I think it's a backdoor way of approaching the question of how many witnesses each side will bring forth.
Mr. Chairman, if I may respond.
Yes.
This is a key point as to why Professor Hill left one department and went to another. And according to her statements, Judge Thomas had sexually harassed her at the Department of Education. And she went with him to EEOC in significant part, if not in major part, according to her statement, because she would have lost her job. Now, Senator Metzenbaum may find that uncomfortable, but I frankly object to his interruption, and the witness doesn't have any problem with the question.
I want to say I'm not wanting to interrupt my friend in his line of inquiry. I'm raising the question with the chair with respect to the procedure. We were all told that there would be only so many witnesses, and unless there was agreement between the chair and the ranking member, that is the number that would be had. But if you have witnesses come in through affidavits and then inquire of Ms. Hill, I think that it just is not following the procedures.
Mr. Chairman, this is a question which goes to the heart of the credibility of what the witness has testified to as to her reason for a very critical move from the Department of Education to EEOC.
There's no question that it is as represented. The question is whether or not the remainder of the committee had any opportunity to prepare to know whether or not this was going to happen. What I am afraid is going to happen now is by the time that Judge Thomas gets here, there will be 2, 7, 10, 12, 15 affidavits that no one will have an opportunity to look at, and Judge Thomas will be questioned on things that could be totally scurrilous, could be, in fact, totally off the wall without any of our staff having an opportunity to determine whether or not the person proffering the statement is, in fact, credible, and whether or not that person should be called before the committee.
Mr. Chairman,
Yes.
I make a statement.
Yes.
I think the question is proper because without this affidavit, you don't need the dogged affidavit.
Well, I would
He could ask her the question that he did ask her, why she left when she could have stayed. Without this, you don't need this affidavit. The question you asked is perfectly proper.
Well, Mr. Chairman, just on this issue, it's being represented that Singleton had a job available for Professor Hill. I mean, I think it'd be legitimate to find out when did Mr. Singleton indicate that Professor Hill might have a job? Did he have a conversation with her prior to the time that she left the agency? Here, a senator is saying, well, don't you know that Mr. Singleton, who happens to be one of Clarence Thomas's best friends, had a job
And why didn't you take it? And the fact you didn't take it must reflect something, and I think all of us know what is trying to be reflected. And so I think it's perfectly appropriate for us, when we're going to talk about asking a witness about when that job was available, to know when that job, whether Mr. Singleton talked to Professor Hill, when he talked to her, when he indicated a job was going to be available, rather than just go ask the witness right here in an affidavit. At some time, Mr. Singleton concluded, based upon your standing over there, that you would have been available. And I think that's the point the senator from Ohio is making. I think it's legitimate.
The chair.
If I may respond just briefly.
Yes.
The question is whether Professor Hill, she is in the process of leaving. She is concerned about her job, and the question which I asked goes to the issue of her inquiry as to her ability to stay because she's in a Class A status, or secondarily to keep the same position as the Assistant Secretary's advisor. Goes to the issue of her state of mind as to whether she felt she really had to move with Judge Thomas to keep a job.
Now, wait a minute. Let me say something.
Before you roll, I'd like to make a statement.
Make it briefly if you could.
I'll try. It seems to me that these questions are relevant. I'm sorry. It seems to me that these questions are relevant. Last night, we were trying to obtain all the knowledge we could from this so-called Angela Wright. Well, she gave so much testimony and then refused to talk after that. Now, does that mean that she's going to be barred from testifying? I don't think anybody on your side is going to argue that. He's entitled to ask her in advance what her recollection is of these things. And all that means is that she'll answer it. Either she agrees with the statement or she doesn't. If she doesn't, she doesn't. Now, if she doesn't and the Singleton statement says something else, we have an option of calling Singleton or not calling him. I mean, that doesn't take anybody's rights away from them. And I think if she wanted to, she'd have an option of coming back if she didn't like what he said. So I think, I never heard of this rule.
I thank my friend.
Mr. Chairman, I do wish to make one point on this. How fair can it be to either Professor Hill or any other witness if any of us could sit up here and say, when I have this stack of affidavits, and on affidavit number 5 in the third paragraph, somebody says such a, what do you have to say about that? I mean, at the very least, I'd be able to see these affidavits. At the very least, you ought to have some idea who the person is and who they're credible. Otherwise, you go down through a whole list and say, aha, affidavit number 29, second sentence, they say that you were living in Japan at the time. Can you prove that you were? I mean, this doesn't make much sense. There's no procedure.
I thank my colleagues for their advice. The chair rules as follows.
Mr. Chairman, may I just,
You've been very good.
I promise I've tried. It's a very difficult day for me. Mr. Chairman, let me just say, every one of us at this table is in anguish because what we're trying to deal with is the credibility of these two people, principally. And so anything that goes to their credibility, we have to hear. Forget about dogged. I'm glad you responded. I think that was appropriate because that thing would be splattered all over the place. And if you hadn't said anything, you'd pay for it. And so now, you can't tell me what you're going to do when Clarence Thomas gets here and you bring up any questions impugning his credibility. Are we going to invoke this rule? I want to see it to believe it.
Well, let me
This
tell
is
you.
about credibility.
Let me tell you what I'm going to do, and then I'll yield to my colleagues. I'm going to speak. Let me tell you what I'm going to do. It is appropriate to ask Professor Hill anything any member wishes to ask her to plumb the depths of her credibility. It would be appropriate to ask her about Mr. Singleton, but it is inappropriate to represent what Mr. Singleton said via an affidavit. There is a distinction. So you can ask anything you want. You can ask what Santa Claus said or didn't say, whether she spoke to him or not. But it's inappropriate to introduce an affidavit from Santa Claus prior to every member in this committee having an opportunity to check it out for the following reason. We may find out that Santa Claus is not real. Therefore, it may not be very relevant whether or not Santa Claus said something or not. So we're all lawyers on this committee with one or two exceptions. There is a fundamental distinction between being able to ask a question, to determine the credibility of a witness, and representing what an individual said they said, or said they offered, or said they thought about the motivation of the witness. There's a distinction. And so the chair will rule you can ask anything you want about credibility. You cannot represent via an affidavit or a sworn statement or a statement as to what the individual being asked about thinks. If that is the case, ask the committee to bring that witness forward. And then we will sit down and renegotiate among ourselves and with the White House how many witnesses we're going to have. But as pointed out here, this is another way of getting in 2, 5, 7, 10, 20 witnesses without their being able to be cross-examined, representing what they said. Now, that is the chair's ruling. Did my friend want to say anything?
I would just buttress that by saying there's one other reason, Mr. Chairman, and that is if we don't abide by the rules, we're going to end up in these wrangles constantly every time a new affidavit is brought up.
And I assure my friend from Wyoming that I will impose the same exact rule on anyone questioning Judge Thomas. Now, the senator from Pennsylvania has the floor.
Mr. Chairman, am I accurate that I only have 29 minutes left?
You have whatever time was. Let me ask Senator
29
Simpson
minutes
how
on
much
my 30-minute round.
Pardon me?
Is it accurate that I only have 29 minutes left on my 30-minute round?
It's accurate. You can have as much time as you want.
Thank you very much, Mr. Chairman. Professor Hill, did you know that as a Class A attorney, you could have stayed on at the Department of Education?
No, I did not at that time.
Did you make any effort to find out that as a Class A attorney, you could have stayed on at the Department of Education?
No, I relied on what I was told.
Sorry, I didn't
I
hear you.
relied on what I was told by Clarence Thomas.
Well,
I
my
relied on what I was told by Clarence Thomas. I did not make further inquiry.
And what are you saying that Judge Thomas told you?
His indication from him was that he could not assure me of a position at education.
Was that when you were hired or when he was leaving?
When he was leaving.
Did you make any inquiry of his successor, Mr. Singleton, as to what your status would be?
No, I did not. I am not even sure that I knew who his successor would be at the time.
Well, was Mr. Singleton on the premises for about 4 weeks in advance of Judge Thomas's departure as the assistant? May I finish the question?
I'm sorry.
May I finish the question?
I'm sorry.
Was Mr. Singleton on the premises for about 4 weeks prior to Judge Thomas's departure for transition?
I don't recall.
Did you make any effort at all with anybody in the Department of Education to find out whether you could stay on in a job there?
As I said before, I did not make any further inquiry.
Well, how concerned were you on your decision to move with Judge Thomas to EEOC, notwithstanding your represented comments about retaining some job somewhere?
I'm sorry. Could you
Well,
rephrase the
I'll
question?
be glad to repeat it. If you made no inquiry to see if you could stay at the Department of Education, perhaps even as the assistant to the Assistant Secretary of Education, how much of a factor was your need for a job to go along with Judge Thomas, even though he had made these reprehensible statements?
it was part of what I considered.
Professor Hill, there has been disclosed into the public milieu the records of certain telephone logs as so much of the evidence or representations or comments about this matter. And you were quoted in the Washington Post as saying, quote, "I am terribly saddened and deeply offended by these allegations." Ms. Hill called the telephone logs, quote, "garbage," unquote, and said that she had not telephoned Thomas except to return his calls. Did you, in fact, say that you had not telephoned Thomas except to return his calls?
No, I did not say that.
Washington Post is in error on that
Well,
statement attributed to you.
I can tell you something about that conversation.
Please do.
When that conversation was made, it was my indication that the reporter was saying to me that we have information that you talked to Clarence Thomas 10 or 11 times over this period of time that was described. That was my understanding of what she was telling me. I knew that I had not talked to Clarence Thomas, and I told her that. I said, I haven't talked to Clarence Thomas 10 or 11 times. And she said that there were telephone logs that indicated that I had.
Well, it's not.
Receipt of those funds. I would be concerned about it, and I think, as I noted earlier, I certainly would be concerned in this case that there would be some condition on the exercise of our First Amendment rights.
But and I am not suggesting that obviously you have not had a chance to look at anything in depth here, but to get a feel for where you stand. A little more of a feel than the generality that you just gave us. You're just off the top of your head instinct. Would the government have the right to restrict what libraries can, what books they can have in a library?
Without committing myself, Senator, could I?
Without committing yourself,
view,
I don't want you to commit yourself to doing certain things. I don't want you to be on the bench and think, well, I told the Senate committee this or that. But I am interested in knowing what your feeling is on the first.
Let me give you, I would hope that the government can't do that. I would have grave concerns if the government can through simply providing funding, undermine fundamental rights. It would be my hope that that could not happen.
All right. Let me, I have some other examples, but let me get to a more specific example that you were involved in at the EEOC. There was a man named Frank Quinn who was in charge of the San Francisco district. He was the district director. 9 months he was going to retire. He had high ratings. He was asked by Newsweek magazine to comment, and he gave a comment that was not complimentary to the Washington office of the EEOC. And then he was transferred to the Birmingham office. No disrespect to Birmingham here now. I may get in trouble with my colleague. Transferred to the Birmingham office, where they had had a vacancy for a full year. And he went into court, and a judge appointed by President Nixon, Judge Schnacky, said, in upholding Frank Quinn's right not to be transferred, said, "We have, I think, an overly outraged reaction to the initial publication, demonstrating, at the very least, deep anger at the temerity of anyone in Mr. Quinn's position to make the statement that he did. On the evidence before me, I can find absolutely no rational basis for the agency's conduct. All of the evidence tends to support Mr. Quinn's view that this was a deliberate, arbitrary, and capricious desire to punish him. I haven't the slightest doubt Quinn was transferred as punishment for the exercise of his First Amendment right." Now, you may want to comment on the case, but the more fundamental question is, how do you view First Amendment rights for government employees?
Senator, I fundamentally disagree with that statement, and I did then and I do now. When I arrived at EEOC, I established a policy and made it clear to all district directors who are members of the senior executive service that they would be rotated. I had rotated some into headquarters from the field offices, in fact, one from Birmingham, and intended to rotate the others across the field. The indication that this was in response to an article, I do not believe I had seen the statement in the article, and certainly it had no bearing whatsoever on my decision to move Mr. Quinn. I've stated that and would continue to state that. And if I did, I think it's inappropriate. My own view is that individuals, I would hope that individuals who worked for me wouldn't feel the need to criticize me publicly, but I think they have the right to do so.
And they have the right to do that without being transferred or anything like that?
I think so. But this case was not that point. Others have criticized me, and I certainly with no efforts against them. I think that this was confused in this case with a policy that I thought was important to the development of EEOC as an agency. When I arrived at the agency was stagnant. The agency needed some stimulation, and I believe that the agency needed to have the managers moved around, sort of stir up the water somewhat. And I made that clear, and we did rotate managers and continue to rotate managers.
You can understand the judge's assumption, because it happened only a few days after the Newsweek article appeared, that he was transferred because of that.
That's been quite some time, but I think that had been in the works prior to the Newsweek article. I had made a number of decisions early on in my tenure and simply began to implement them. That had, from my standpoint, no relationship whatsoever. And I don't remember that what he said was particularly offensive anyway.
You made a talk to the Kansas City Bar Association referring to the Newsweek article, and you were unhappy with the Newsweek article. Obviously, you happen to remember.
But not to Quinn. I don't think I referred to Mr. Quinn. I thought that the article was off base, but I didn't refer to him, I don't think.
I frankly don't have that here. I don't know. But in terms of basic freedom of speech, for if an employee of any federal agency speaks, and obviously some things are confidential, some things are classified, there are some limitations, but just because something would be embarrassing to an agency is not a cause for restricting freedom of speech for a government employee.
It certainly wasn't from my standpoint, and I would be concerned if, as an employee, my speech was in some way impeded.
In an area where you have expressed your opinion here to the committee on the death penalty, where I happen to be in a minority on this committee in regard to the death penalty. Two realities are part of the imposition of the death penalty in our country. One is, it is a penalty we reserve for people limited means. If you have enough money, you hire the best attorneys, you never get the death penalty. The second reality is that it is much more likely to be applied to minorities. If you're black, Hispanic, Asian, you're more likely to get the death penalty. We have executed in this country literally hundreds of blacks for killing whites. So far as I have been able to determine, my staff's been able to determine, only 2 whites have ever in the history of the country been executed for killing blacks. If you were on the court and the circumstances were such that you felt that economic circumstances dictated a lack of qualified counsel for someone who received the death penalty, or you were persuaded that the fact that a person was a minority was a factor in receiving the death penalty, what would your attitude be?
Senator, it would be similar to the attitude I have now that I expressed here. I don't know of any judge who could look out the back window of our courthouse and see busload after busload of young black males and not be worried and not be concerned and not be troubled. I think it's only exacerbated by the fact that it's a death penalty. And as I've noted earlier in these hearings, one of the reasons that it's so troubling is that it is a very fine line between my sitting here and being on that bus. And I think that any judge who has that obligation and that responsibility of adjudicating those cases and has that responsibility of reviewing those cases should be concerned if the death penalty is imposed based on socioeconomic status and certainly imposed on the basis, or at least to a large extent disproportionately on the basis of race. It was certainly something that I am concerned about at this point and would continue to be concerned about as a judge.
And it would be something that you would have to weigh as a member of the Supreme Court. Am I reading you correctly?
It's something that I certainly go there with in my mind and in my calculus when I think about these issues.
But it's not just that you go that was there with that in your mind, but if you were convinced someone received the death penalty because he or she did not have adequate counsel, for example, would that be a factor in, because of economic circumstances, would that be a factor in that you would weigh, among others?
I think it would be important for me to take that into account.
Okay. Let me shift, and I don't want to, just a couple of loose strings. The J. Parker, South Africa thing we talked about. We have received one additional phone call from someone who says that this has been verified. There was a staff meeting that we talked about. You did not recall. Do you recall this any further at all, this on further reflection, or has anyone reminded you or anything at all?
Senator, I've attempted to reflect on it. My recollection is, as I've told you, I've attempted to try to understand where the confusion could come from. And I knew that J. Parker, for example, represented one of the homelands. That could be a source of confusion as to whether or not he represented South Africa. I also knew that a colleague and friend of mine who worked with me here in the Senate and went on to other endeavors, as well as worked with me during the Reagan administration, represented South Africa. That was a matter of public knowledge. I don't think, I do not remember or recall Jay Parker's involvement being a matter of public knowledge prior to my nomination. I certainly was not aware of it until the last few months. The only confusion that I could think of, and based on my own recollection, would be that he has had significant dealings in South Africa, and someone may have felt, or I may have imprecisely stated that, and they may have felt that he was representing South Africa. But I simply didn't know. I don't recall knowing, and I don't recall such a meeting.
Do you recall, do you now, or have you ever had any financial dealings with Jay Parker?
No, we have no financial dealings. He's a friend of mine.
And again, on the recollection, there just is, you were not aware prior to your nomination and the attention, the publicity that came with it, of any involvement on his part with the government of South Africa other than the homeland?
No, I was not. My recollection was that, again, a mutual friend of ours, a Bill Keys, was represented, and that was public knowledge. He represented South Africa. I was not aware of Mr. Parker's involvement, and do not recall the meeting that you indicated. Again, there may have been confusion, as I've indicated, but I did not. I was in no way aware of that.
Thank you very much, Judge. I have no further questions, Mr. Chairman.
Senator Cole.
Thank you very much, Mr. Chairman. I'd like to commend you on your patience and open-mindedness during this hearing, particularly under circumstances which were at times trying. Judge Thomas, I'd like to give you one more opportunity to talk about what many of us are concerned about, and that is the possibility that you have a philosophy that tends to change with your audience. And I'd like to quote from you the part of a column that appeared this morning in the New York Times, and then ask you if you wouldn't think about it for a moment and comment on it, hopefully to enlighten us. Quote, "The most striking aspect of Judge Thomas's testimony was his disavowal of just about everything that he said in speeches made while he was chairman of the EEOC. Their strident right-wing message was appropriate to his role in a right-wing administration, he suggested, but he donned a new skin of impartiality when he became a judge. Indeed, Judge Thomas went further in his disavowal. He implied that he had made some of his conservative comments partly to please conservative audiences. That was his explanation for his praise for the extreme anti-abortion position of Louis Lerman. But if he tailored his philosophy to please his audiences in the past, might he not be doing so at this time in the Senate caucus room?"
Senator, there's much that's been said, but I don't think that I said that I tailored my message to please an audience. In fact, the Heritage speech was precisely the opposite of that. It was to make the audience uncomfortable. My explanation with respect to the Lou Lerman reference was simply to convince the audience to re-look and revisit the issue of civil rights. The bulk of that speech, the first part of that speech, is a criticism of conservatives as well as the Republican administration. The second point I'd like to make, Senator, is that I do think it's important to have been, to have gone to be a member of the judiciary as opposed to being a member of the executive branch. There's a significant difference. And I have not, through my history at EEOC or on the bench or any place else, attempted merely to please individuals. That has not been a suggestion of mine. I was a member of the executive branch. I think I conducted myself as a member of the executive branch. I am a judge now, and I think I conduct myself as a judge.
But you said that there is a difference, and you said that consistently between being a member of the executive branch and being a member of the judiciary. And certainly there is a difference. That's a simple fact. But you're being considered here as a member of the Supreme Court because of whatever your philosophy is. looking to get at that. Now, are you saying that that philosophy has changed as you move from the executive branch to the judiciary branch, or are you saying that you had a philosophy in the executive branch, but you come now to judiciary with no philosophy?
I said that I think I've indicated I engaged in ideological and political debates and discussion. I participated in debates in policy making. I participated in debates between the two political branches. As a member of the judiciary, I do not think that ideology is important, and I do not engage in those political or policy making battles or discussions.
That's all right, but just one more question, then we move on. I don't differentiate, perhaps as you much, as between ideology and philosophy. I think that what we're saying here is we're asking ourselves and asking you whether the philosophy that you expressed when you were in the executive branch is the same philosophy that you have today.
I am the same person. My outlook is, I believe in our country. I believe in trying to look at a problem and solve that specific problem, to look at a statute or a case and be true to my obligations with respect to that statute or that case. I do not believe, however, that there is a role in judging for the expressions of the kinds of personal views or the policy making or the personal opinions that you have in the executive branch.
That's all right, but would you say that I can't assume that, in general, the kinds of philosophies that you had and expressed, however we interpret those, but those kinds of philosophies that you had and expressed when you were in the executive branch are not that dissimilar from the kinds of philosophies that you carry today?
I am the same person. I think the role, again, the judicial philosophy versus being a policymaker is different. And I think that there is an indication of the kind of person I am when I was in the executive branch and my outlook on life. The only point that I'm making is that to the extent that those are political statements or policy-making statements, I don't think that they're relevant in my role as a judge.
Thank you very much, Judge Thomas. I don't suppose I'll be speaking to you again, at least not in this capacity, and I found you to be a intelligent, bright, and humorous person. With respect to the process itself, Mr. Chairman, I think that one of the things that has come out of this confirmation hearing is that we need to do as much as we can to ensure that the hearings in the future leave us all, if not most all of us, with a little more definite feeling about who it is that we're really talking to and what kind of a person in terms of philosophy that we're voting on. Thank you very much, Mr. Chairman.
Thank you very much. I have questions. It is my turn to come around. What I'll do is I'll ask a few of them, and then I'll yield to the senator from Pennsylvania who asked questions on his last round, and I'll conclude. Judge, I'd like to go right back to methodology, if I may, without any preamble. I'd like to talk with you about the Michael H. case and famous footnote 6, if I may. I don't want to bore the listening public with the esoteric underpinnings of that debate. So let me ask you. You concur with the rationale offered by Justice Scalia as to how one is to determine whether or not an interest asserted by a person before the court, an interest asserted that there's a fundamental right that that person has, whether or not you must go back and look at the most specific level of that interest as asserted, like he suggests, or as historically or traditionally been viewed, a broader look back at the more general interest asserted, as Justices Kennedy and Justice O'Connor indicated, notwithstanding the fact they would you speak with me a little bit about that?
Senator, that's a very recent case, and I'm in the position of not wanting to comment on that specifically, but I am very skeptical.
I'm asking you to comment on the footnote.
I am skeptical of any, when one looks at the tradition and history, to narrow the focus to the most specific tradition. I think that the effort should be to determine the appropriate tradition, or the tradition that is most relevant to our inquiry, and to not take a cramped approach or narrow approach that could actually limit fundamental rights. I think that Justice Kennedy's reference to loving Virginia was a very catching reference. And his objection to
Justice Kennedy's reference to loving versus Virginia
was a very telling reference, and one that certainly caught my attention. But I think that I would be skeptical of that kind of an approach, Senator. Very skeptical of
the
that.
Kennedy kind of approach?
Of the Scalia approach.
Well, I hope so. And your references, Kennedy's references to loving Justice Kennedy, I think and there are other cases we could point to, not just loving, as to whether or not we go back and look in history as to determine whether or not there is a protected fundamental right. In the case of Michael H., the issue there, as you know as well or better than I do, was whether or not a father who in fact was the father by blood of the young person in question, whether or not he had any rights to visitation, notwithstanding the fact that the child was born at the time when the mother was married to another man. And Justice Kennedy asserts that, Justice Scalia asserts that when you go back to determine whether or not there's a personal right to privacy of a father to be able to visit his child, that you go back and not look at whether or not fathers have those rights, but whether illegitimate fathers have those rights. And he concludes, as you well know, that nowhere in our English jurisprudential tradition are illegitimate fathers treated in the way that, quote, fathers are treated. And when you narrow the scope to look that way, you can come out with the ability to suggest that there is no historical background or tradition that protects illegitimate fathers, ergo. And in Loving versus Virginia, as you know better than I, it was a case that ended miscegenation in this country, at least in Virginia, and the country. And if you applied the Scalia method, you would go back and say, is the right of marriage one that we always look to? And Scalia says, no, you don't look at marriage. You look at whether or not miscegenation laws, anti-miscegenation laws were legit. They've always been viewed as that in our unfortunate background, therefore. So that's why it's so important, as you well know, and as I understand it, you are not taken with the Scalia approach. Skeptical. I hope you're more than skeptical, Judge. Well, at any rate, let me move on, if I may, for a moment now to the issue of separation of powers, if I may. And go back to Morrison v. Olson, if I may. I won't bother you with the quotation we've talked about before, which is the quotation about Morrison being the most important case since the Board of Education. And we've talked about this, Brown versus the Board. We've talked about this passage several times, and you've talked about it with Senator Leahy. And I want to ask you why you thought the independent counsel case was the most important since Brown. And your answer, if I understood it when we spoke about it last time, was that you were addressing an audience for whom the topic of separation of powers would seem, as you quote, you obscure, or a topic that, quote, doesn't excite people in the audience. Now, is that correct?
And also it dealt with any case that dealt with the structure of our government. For example, INS versus Chadha deals with the structure of our government and congressional veto. I think those are important cases because I think the Supreme Court has very few cases directly addressing the structure of our government.
Now, I can understand the need, we all do, in each of our businesses, you as in the executive branch and us in the legislative branch, trying to get the attention of an audience that may not want to pay attention to necessary subject. It never happens in these hearings, but it occasionally happens in other places. So I understand the technique, and I don't say that critically, I mean that sincerely. But I never did get around to asking you whether you actually do consider Morrison v. Olson the most important case since Brown versus the Board.
I think it's one of the most important cases. I think it's among the important cases. It's, of course, and I say that because I think the cases that deal with our structure, the structure of our government, are important cases.
Well, I'm sure you know why I was drawn to this quote and comment, and it wasn't so much because that had a darn thing to do with Brown versus the Board and looking whether you thought something else was as important or more or the most important since then. But as you know, there are a group of people beyond yourself who consider the independent counsel case very important, and maybe even the most important case since Brown. And I'm thinking of the libertarians who are devotees of Mr. Epstein and others, those people who have two major items on their agenda, and they state them very forthrightly. One is to use the takings clause of the Fifth Amendment to limit the power of society to regulate. You and I have talked about that. And the other is to limit the power of society to regulate by revitalizing the doctrine of separation of powers. Now, when you gave that speech at the Pacific Research Institute, did you realize the significance of the independent counsel cases for the people with what I would characterize as these, with these views?
This is the first I've heard of that. I've heard of the takings argument, but I haven't heard of the separation of powers argument.
Well, the reason why, again, it was brought to my attention in reading Solicitor General Freed's book, as we mentioned in another context, and Solicitor General Freed and I have had our disagreements before this committee, and he's never been accused of being, at least in the circles that I travel in, of being a liberal. In the book he wrote about his years as Solicitor General in the Reagan administration, he refers to a group of executive branch employees, primarily in the Justice Department, whom he refers to as, and I quote, Reagan revolutionaries. Now, Professor Reed writes of these so-called revolutionaries and what they thought about the independent counsel case and why they thought it was such an outrage, such a horrible decision that is upholding the independent counsel. But they also thought something else, he said. They thought that if they could get the court to strike down the independent counsel statute, they would have a basis for striking down all independent agencies. Because the rationale that allows the independent counsel case to be struck down would allow the Security and Exchange Commission, the Federal Trade Commission, the Federal Communications Commission, the Federal Reserve Board, which is one of their primary targets, to be struck down. And according to General Freed, this group wanted all of these agencies placed under the thumb of the president rather than continuing to operate with a modicum of independence from the day-to-day political influence. Now, and I quote from his book on page 154 of Order and Law, he says, to the revolutionaries of the Reagan administration, the independence of the independent regulatory commissions, for instance, the ICC, the FTC, the FCC, the SEC, and most importantly, the Federal Reserve Board, was an offense against the principle of the unitary executive and of the separation of powers. So he goes on to say that's why Morrison was such a big deal to so many people and still is to so many people. Bright, attractive, and energetic people who would like very much, nothing wrong about it, but like very much to change the regulatory process and agencies in this country. And if Justice Scalia's opinion, the lone dissent that you found so remarkable in, and that's your word, remarkable, in the Morrison case, had been the majority opinion, all of these agencies would be unconstitutional. If Scalia's opinion, dissent, were the majority opinion, including the Federal Reserve Board, an independent agency that served this country extraordinarily well in recent years, most might suggest. And because of the rationale of Scalia's opinion does not stop at the independent counsel statute. It would outlaw all independent agencies. Now, Judge, you believe that the separation of powers requires the abolition of independent agencies in the federal government?
Senator, I have not thought that. In fact, I was on the other side of that debate. But let me just walk through it a second. EEOC was one of the rare independent regulatory agencies in the executive branch.
Stop you there. As you know, there was a debate at the outset as to whether or not EEOC was in fact truly an independent agency and designed to be one, unlike the FCC and others, which clearly, unequivocally, were meant to have independence in that the president could not dismiss without cause.
Well, that debate about EEOC was, for all practical purposes, conceded in the Reorganization Act of 1978. And my argument as the chairman of EEOC was that EEOC needed to be independent, that it was enormously difficult. As one of my commissioners put it, we had the worst of both worlds. We were one of the few independent agencies or commissions that had to have its regulations cleared through the Office of Management and Budget and engage in a process that the other executive branch agencies had to engage in, and there were problems with that. And so I advocated just the opposite, that it be truly independent. I was aware of the academic debate years ago, particularly after the New Deal era, concerning administrative agencies. I did not participate in that debate during my chairman of EEOC, and really just thought it was nothing more than the debate that you would place next to the gold standard debate.
It's alive and well, I must tell you.
There are some limits to the things that I can spend my time on, but I was not involved in that debate and was not aware that there was a relationship or there was a second agenda to Morrison v. Olson. This is news to me as you explain it today.
Well, Judge, in light of what you know now, you do understand why this is such an important issue to question you on, don't you? I mean, if you look again at the dissent in Justice Scalia's dissent, and he has been consistent, by the way. This is not a new notion for Justice Scalia. He takes separation literally, and as you well know, he is in a position where he suggests that Article 1, 2, and 3 set out the parameters for each of the branches, and they do it very precisely. And that any branch that in any way voluntarily or involuntarily treads on the prerogative of another, and in this case, if there's any executive capacity or judicial capacity that any of these agencies possess, then in fact they have gone beyond what is legitimately authorized in the Constitution under the separation of powers doctrine. Doctrine, I might add, is not anywhere mentioned explicitly in the Constitution, but so this is a big deal. And if there were 5 Justice Scalias on the bench, we would find ourselves with a radically different means by which we would be able to have this government function. I'm not being pejorative when I say that. For argument purposes, he may be right, but it would radically change it. The FCC has judicial functions as well as legislative functions. It has rulemaking capacity. He argues, rulemaking capacity, that's legislative, can't be done. In Morrison, he argues, wait a minute, you still have you put in effect the executive branch in a position where it has to assign a special counsel. So notwithstanding the fact you allegedly give it independence whether or not to determine whether such counsel exists, you've already stepped over the line. Therefore, it is unconstitutional because the legislature is taking on some executive function. So, and I'm not being facetious when I say this, do you understand why his dissent is so significant if it were to be the majority view of the court? Or do you disagree with my assessment of his dissent?
Well, in the context that you explain, I can understand your concern. My quote and my reference in the speech was that with respect to the individual rights that were affected in this particular case. But
I'll accept that on its face because I believe you mean that, and believe it or not, I am delighted to hear that is the case and not the larger case, because there is when I say agenda, I don't mean it again to sound so pejorative when I talk about an agenda out there unrelated to you. But I think we should understand that there's a good deal of intellectual ferment. I must admit one of the reasons why the right has been so successful is there's much more intellectual ferment on the right than there is on the left today. I think the left has fallen back on its laurels in many ways. It finds there's no need to come up with new methods and means by which to promote its objectives. But that is not lacking on the right, and there is an explicit desire, not at all denied by any of the young intellectuals who wish to see a change, that the way to deal with too much government bureaucracy and regulation is to eliminate the regulatory bodies that exist, thereby giving the executive total control over those elements of regulation as opposed to the legislative body. I won't bore you with that. I accept your answer for what it is to be the truth, and I will, at this moment, unless you'd like to add anything, I will yield to my colleague in a moment. I suggest maybe we should break, to give you a break, unless you have a comment to make on what I said, and I'll yield to my colleague when we come back, Senator Specter, and we'll have you question then, Senator, okay? We'll yield to give the witness time to stretch his legs a little bit, 10 minutes.
And another afternoon break at the Senate Judiciary Committee hearings on the nomination of Judge Clarence Thomas to serve on the Supreme Court. Judge Thomas getting a chance to stretch a bit. This is his 5th day in the witness chair. He's been accompanied to these hearings by White House lobbyist Fred McClure and his chief sponsor, John Danforth from Missouri. And we just heard some additional questioning from Democratic Chairman Joseph Biden, who has perhaps been the most persistent questioner at these proceedings. Nina?
That's right, Paul. And in fact, what we just heard was a line of questioning about a case called Morrison versus Olson, which was the case in which the Supreme Court, in an opinion by Chief Justice William Rehnquist, upheld the constitutionality of the statute that provides for the appointment of an independent counsel to investigate scandals, wrongdoing that may have occurred in the executive branch. And what was, I thought, particularly interesting about that exchange, Paul, was that I think it was another example of the kind of thing that Professor Mary Che was talking about just a few moments ago, or an hour or so ago, when we had our last break. And that is, in some senses, the lack of knowledge demonstrated by the nominee. And I realize that sounds harsh, but he was being asked by Senator Biden about this case on the independent counsel statute. And Senator Biden said to him, did you realize that this case was being used as the landmark, that if it went in the way of striking down the independent counsel statute, it would next be used to attack all the independent agencies? And the nominee, Judge Thomas, said, well, frankly, that's news to me. I didn't realize that. He said rather graciously, I think, and truthfully, obviously truthfully. But I have to tell you that as one who covers the Supreme Court, if one is to give a speech in which one praises the sole dissenting opinion in that case and savages the majority opinion, and one does not know that that's what that case stood for, was an attack on the whole structure of independent agencies, it demonstrates a certain level of a lack of knowledge. And that's, I think, what Professor Che was talking about earlier.
And I think the Democrats have been trying to get at that most pointedly today in their questioning. They've not only been trying to draw Judge Thomas out, but I think they've also been trying to get a good feel for his knowledge or his lack of knowledge about these prominent cases.
It's certainly not fatal, and it's not going to kill this nomination, but it is material. And it is worth noting that this is yet another example of that. And I also want to raise a question here that has not been raised by the senators, and that is that this nominee, when he was head of the Equal Employment Opportunity Commission, gave literally hundreds of speeches, and a lot of them were quite doctrinaire, and one wonders whether he wrote all these speeches. I'm quite sure he didn't. He had speechwriters. Did he write this speech? Did he review this speech before he gave it? How much input did he have into the speech? If he wants to disavow some of these speeches, one wonders why senators haven't asked him about his speech writing.
Well, that raises another question, Nina, and that is, was he a mere emissary for the Reagan White House, which we know had a very definite philosophy about many of the things which Judge Thomas had to handle when he was head of the government's chief anti-discrimination agency? He seems to be taking that as a policy officer. There were a lot of debates that took place within the inner councils of the administration. And he went along with some of these things, but they didn't necessarily mean they represented his views, because what we've seen at these hearings, of course, time and time again, is that he has backed away from some of those positions. And I think it's fair to say that he has tried to convey a much more moderate, much more flexible image. He keeps saying that when he was in the government, when he was in the executive branch, that was a different kind of job.
And it was.
Right. And now that he's going on the court, he sees service in the judicial branch in an entirely different way. That here, the chief qualification should be that you are an impartial person, that you're an arbiter. And from that, he seems to be deducing, I have to think differently. I have to look at these things differently now.
Certainly, history is full of people who are able to don different robes. I guess the most recent example of that I can think of is that now retired Justice Lewis Powell, at the time of his confirmation hearing, was questioned repeatedly about a speech he gave in which he said, flat out, that he did not think a warrant was necessary in order to wiretap individuals in national security cases, foreign security cases. And he kept saying at his confirmation hearing, my role will be different when I'm on the court. Well, lo and behold, in less than a year, he wrote the unanimous opinion for the court that struck down the then Nixon administration's policy of not having warrants for these kinds of searches or these kinds of wiretaps, saying that they are required by the Fourth Amendment guarantee of protection from illegal search and seizure and the requirement that there be a warrant in these kinds of searches. So we can see that people are able to change roles, are able to change robes when they get to different positions in life.
And what you have to say, in the case of the White House, what the White House thinks it is getting may not necessarily be what indeed it is getting in these matters. We have joining us now Margaret Wilson, who is a former official of the National Association for the Advancement of Colored People, who now practices law in St. Louis. And Mrs. Wilson, I understand you have known Clarence Thomas for a long time. When did you first meet him?
In the year 1974.
In St. Louis?
In St. Louis.
What were the circumstances?
John Danforth, who is a good friend, told me that he was bringing a young man from Yale to serve on his staff.
In Missouri?
In Missouri. Danforth, of course, was then Attorney General. And then he said, by the way, he's a black man. I said, oh, wonderful. And a little later he said to me, have you any idea where he could live for the summer while he studies for the bar? just so happened that my own son, who was in law school, was not coming home for the summer. And almost kind of instinctively, I said, aha, I can have a fine young person in my home. And so I'm sure Danforth's astonishment, I said, yes, I did. He said, you do? And he said, where? I said, in my home. And that's how it happened. Probably in April. So 2 or 3 months later, my doorbell rang, and there stood Clarence Thomas.
And did you find him to be, even then, an independent-minded, sometimes stubborn and obstreperous house guest?
I wouldn't characterize him as obstreperous, but Clarence Thomas was then completely determined to be an independent thinker. And one of the fascinating things that I remember of the dinner table discussions we would have almost every day, in which we would be just pounding the table, discussing issues of the day.
So you think these hearings do bear out the fact that Judge Thomas is an independent thinker, which indeed he's been saying
absolutely.
At these hearings?
Absolutely.
What did you fight with him about?
As I remember it, Clarence even then was convinced that the welfare system had made people too dependent and had stripped them of their... And while I think that is true to some extent among some people, I also think the government has been the way in which most people in this country have progressed, and I don't know why we should be reluctant to receive the same support.
We can talk a bit more in a moment, but the hearings have resumed, and Republican Senator Arlen Specter is now putting some to Judge Thomas.
Because they are two 1971 opinions by unanimous Supreme Court, with the opinion by Chief Justice Berger in a very conservative trust. Is Swan versus the school districts. I ask you about this case because you had written on the subject Boaz edition of Assessing the Reagan Years, and you complained about not only ended segregation, but required school integration. My first question to you is, if you end segregation, doesn't it necessarily mean that you are requiring school integration?
Well, I guess the semantic reference that my own reference to those two different terms would have been that desegregation, the ability to simply not be barred from certain activity, and more positive, that is, you're required to have a certain percentage or certain number.
Does your criticism of the Swan case, another one of the illustrations of your advocacy from the executive branch, or is this something you really think should be changed and something you would try to change if confirmed for the Supreme Court?
Senator, the answer to the second portion of your question is the same as I've said in other areas. Agenda to change existing case law. That's my predisposition. It's not the way that I approach my job. The concern that a number with respect to